population. So, I was very sensitive to the whole issue of disparity. And it needed only to have brought to my attention that on the surface, there appears to be a lot of progress at Morgan, at Coppin, MS, University of Maryland Eastern Shore, and Boyd, but in reality, many of these observations were 10 and 15 years late in some cases. So that began my journey to really look at the underlying reasons for that, and my having had a conversation with Dr. Richardson and understanding that, like many, there was a need to really do something about this. And essentially, that's the conversation that began my journey. And it has been a journey, it has been a labor of love. Outside of this case, I'm fully employed working with the minority and women manufacturing companies, the whole supply chain stuff. So this has been something that I've been doing only because of my love for Morgan, my love for HBCUs, my parents having gone to HBCUs in South Carolina. And I came to Morgan, by the way, on what they call a black scholarship. That was back in the day when they were sending minority students outside of the South because they didn't want us to stay. And so it's been a total journey, and I look forward to more interchange with you and understanding more about the case as we move into the current stage of the case, which will be presented to you, and I'm surely discussing more detail about those on the panel this evening.
Thank you. Good evening. I'm Delegate Aisha Braveboy, and I'm chair of the 44-member Legislative Black Caucus of Maryland. And my involvement in this issue came as a result of being elected chair of the Black Caucus. And I wanted to make sure that the caucus was focusing its attention on issues that were important to the African American community and, of course, the community at large. And as I researched several different issues that were impacting African Americans here in our state, one that stuck out was the plight of our historically black colleges and universities. And a couple of months after I got elected and I took office, the coalition's case was the final oral arguments that was before the district court. And I went down to to hear the closing arguments, and I can tell you that I was embarrassed as a legislator. I could not believe that the state had put itself in a position to really be defending very specific discriminatory practices that the state has engaged in over numerous years. It didn't start with any one, well, in this administration that's currently in office. However, I believe very strongly we could have resolved these issues and we could have moved forward as a progressive state on the issue of parity for historically black colleges and universities. And I'm a lawyer by training, and as lawyers often do, I had to just do my research. And as I researched the cases, as I researched the historical documents that were presented as evidence in the case, I realized that the state of Maryland has known of its own discriminatory practices dating back from 1937, when the first report was commissioned that discussed the plight of historically black colleges and universities. And so as we move forward as a state, and as we move forward as the members of the HBCUs, we have to be absolutely focused on parity, on comparability, because what we know is that our historically black colleges and universities are more important now than ever, because our state has increasingly become more minority. 30% of our state is black. We have a growing minority population, and we understand that the HBCUs have provided really the foundation for wealth for black people in this country. And so as the state wants to grow and increase its prosperity, the what happens here at the HBCUs, what happens to our students who attend these institutions is ever increasingly important to the future of our state. And so that is why I'm here, and I look forward to the dialogue and the questions.
Thank you. Good evening. I'm Earl Richardson. I think that both speakers thus far have been much too modest in introducing themselves, and I need to say something about David Burton. David Burton has been president of the coalition since its beginning, as he said before, but without people like David Burton working day in and day out, representing the interests of our historically black colleges, then we wouldn't be here this evening. And as I look at some of the development here at Coppin, some of that would not have happened without the pressure that has been applied through the coalition. So David, I want to thank you publicly for what you continue to do. Brave boy, I also want to commend you. I think you have been very brave, along with Senator Joan Carter Conway, in introducing so many bills to try to get the state to understand that when you further the interests of our historically black colleges, you further the interests of all Marylanders, that indeed our state is better only when it treats all of our citizens equally and provide for them an equal educational opportunity, no matter what university they choose to attend. And then finally, let me say, before I say anything on my own, I want to recognize Dallas Evans, the former chair of the Board of Regents of Morgan State University. Oftentimes, I'm given much of the praise for what has happened at the university, the praise for what some of this is going on now. Some I want to own and some I don't want to own. But without a chair like Dallas Evans that understood the plight of our historically black colleges, then this would not have been possible. So thank you, Dallas, and glad that you're here this evening. As I said, I'm Earl Richardson. I was president of Morgan State University for 26 years. And after having labored there, doing everything possible to do the best job that we could, we still found that Morgan, as well as all of our historically black colleges in the state of Maryland, still were challenged to be as competitive as our counterparts because there was not the same investment. You hear the rhetoric all the time that the dollars coming to our historically black colleges on a per student basis, is equal to or more. When we say underfunding, we're not talking just about the operational money per student, per degree. We're talking about the total investment in that university, that there has not been the capitalization. You know, when we talk business concepts, we say that if you're going to have a viable business, that you must invest, you must capitalize that business so that it then has the capacity to grow, to be viable, and to continue into the future to be the kind of organization that is always on the cutting edge. That investment has not been made in our historically black colleges. And oftentimes when they start to make those investments, they oversell them and talk about all the extra capacity that you have. Well, that's the business model. For a while, you will have that extra capacity. But it's only when you have invested the resources to the total university, not just one program, not just two programs, but in the total program, that in fact, you have the equity, you have the competitiveness that our institutions need to attract students regardless of race. And let me just punctuate that by saying educating black students and educating white students is not mutually exclusive. And it is not just our white institutions that can attract a diverse student body. Students go where they see quality programs, even those that may be prejudiced. If that's the only way they can go, they will go, because they too understand how important it is to get an education. So I say to you, I'm interested in this subject for the very reason of what it suggests when our institutions cannot perform, when they don't have the resources to perform. It not only speaks of education, it speaks of all of us. It sends the wrong message, that if it's black, it's inferior, and that it's incompetent, that it's mismanaged. Well, I think that you should ask the question, why? And it's in the why that we get the answer to what we're going to talk about this evening. Thank you so very much, and I will await the discussion.
Good evening, everyone. I'm John Britton, and I am David Burton's lawyer in the suit called Coalition for Excellence and Equity in Higher Education of Maryland versus the State of Maryland. In the past, I've been a civil rights lawyer in Mississippi. I spent 22 years at the University of Connecticut School of Law. I was the dean of the Thurgood Marshall School of Law at Texas Southern University in Houston, a historically black college and university. And I am the immediate past chief counsel for the Lawyers Committee for Civil Rights under Law. Indeed, when I was the chief counsel for the Lawyers Committee from 2005 to 2009, I accepted and brought the coalition suit into the Lawyers Committee, and we joined with one of our pro bono counsel firms, Kirkland & Ellis, and today my colleague Mike Jones, a senior partner at Kirkland & Ellis, along with my successor John Greenbaum, and I are the three lead counsel in the Maryland case. I'm so proud of all of you to come out on this fine spring day after this terrible cold winter we had to show your interest and your stimulation in what is the future of historically black colleges and universities. I graduated from Howard University Law School in 1969, so I would be considered, an old geezer lawyer 45 years later now. But my mentor, Herbert O. Reed, who was one of the lead counsel in the case called Bowling versus Sharp, that's one of the quintet, the 5 cases in Brown versus Board of Education, was my mentor. And Reed, along with Thurgood Marshall, was taught by the famed Charles Hamilton Houston, who was the father of the modern day theory that de jure, Jim Crow, segregation is inherently unequal and a violation of the 14th Amendment Equal Protection Clause. So Houston taught Reed and Marshall, and Reed taught I. So I consider myself, in the words of Charles Hamilton Houston, a social engineer, for he said, a lawyer is either a social engineer or a parasite on society.
Good evening. My name is Joan Carter Conway, and I actually chair Education, Health, and Environmental Affairs in the Maryland Senate. And ironically, because it's an educational policy, any bills relevant to K-12 or higher ed actually comes to my committee. And I had the opportunity to talk to Dr. Richardson because I was very disturbed. And I see Dr. Emery over there. In reference to a decision that MHEC had made in 2003 in reference to the duplication of programming. And we fought that battle, and then finally Morgan appealed it, and in 2005 they rendered the final decision that unnecessary duplication, or they could duplicate the programs at historically black institutions. It was at that time I consistently talked to Dr. Richardson relevant to what had transpired, how it transpired. It was always my contention that it was unconstitutional. Nobody seemed to believe me at the time that it was unconstitutional. Morgan Board of Regents, everybody at Morgan knew that it was unconstitutional. So at the time I had asked Dr. Richardson, and we were very, very upset about the decision that was rendered. And it was like, now what do we do now? I said, what we do now, we put in a bill. That's what we do now. So it was with Dr. Richardson's assistance, the research and the data, that I had told them that we would put in a bill that said that we will not duplicate historically black institution program. And ironically, the first bill that we actually put in, I think it was Senate Bill 987, 989. I've had so many bills, okay? I'm really known for the infamous bill of Senate Bill 29. Everybody across the nation knew about that particular bill because even the individuals in California and OCR was actually discussing it. But in 2006, what the bill actually said, that passed the General Assembly. It passed, okay? It passed the Senate, like 41-0, and the reason why I say 41-0, some of my colleagues weren't there. I think it passed the House 137-0. It's 141 of them over there. But they didn't understand the bill. I mean, it just zoomed through the General Assembly. They really didn't get it. They really didn't understand it. But when the Attorney General began to look at the bill that had passed in 2006, they said, oh no, because it was a parity bill. Parity in terms of operating funds, parity in terms of capital, and they just didn't get it. It just seemed such a nice bill. It was a little long. But the AG ruled, and of course he informed the governor at the time, and it was under the Ehrlich administration, and the bill was vetoed. But from 2006 on, I consistently put in the bill asking for parity, and the other bill would actually said that you could not duplicate historically black institutions programs. Now, I could go on forever, and I could tell you some stories, but right now I'm going to pass it on to this marvelous gentleman sitting next to me, and I will definitely be open to any questions that you have to ask me. Thank you.
I'm John Organ. I was the chair of the Faculty Senate at Bowie for over 20 years.
Put the mic a little closer.
I was the chair for over 20 years. And I've been working, and again, I'd like to thank Coppin for having the guts to come up with this program. You don't know how hard it's been. I was at the court cases, and as you can see, I'm an old man. And I thought I was back in the 50s when the court case was being heard. The things that they were talking about, I've lived it. And so when I talk, I'm not talking for things that I don't know. I'm thinking about talking about things that I've gone through. So I've been on top of it. I've been working at Bowie, trying to get the faculty concerned. But before I say another word, I'd like to introduce the chair of the Faculty Senate, Dr. Pat Westerman. Please stand. I stepped down because sometimes you need to hear another voice. See, the Don Sterling, Dr. Kerwin of the university system, and I can say that because he's disrespected me more than anyone. When he writes me a letter because I'm concerned that our president moved our graduation commencement exercise from Bowie's campus to the University of Maryland, and the chancellor said it's all right. It's not all right. When we didn't have anything, we took and stayed where we were. And then for a man to come in and ruin the history of the university, and you tell me it's all right, and when I say something about it, when I write to you with a concern, you write and tell me I need some class and grace. That's what he told me. When I said that our alumni is upset about the move, he said most of them would not be coming to the graduation anyway. These are racist terms, people. These are racist terms. And I'm so glad that he's gone, but he's done so much damage to us before he left. He bring these insecure, ineffective Uncle Toms over to the university system. And they don't work for us, they work for him. And until we get some guts and stand up, then we can have something to say. But we have so many faculty members. Dr. Westerman called a meeting the other day. The only way the faculty members came was because she said, we're going to talk about money. Money is all right, but the university is closing down. When I write to the chancellor and say it's wrong for you or the school to take money from students in scholarship and give them to athletes, Here you are borrowing money to go to school, but part of that money that you're borrowing is for athletic scholarships, and you're paying that. And he tells me, all right, but yet and still, the board is upset about how much books cost. But he's not concerned about how much you are paying in athletic fees. You look at the athletic fees at Bowie, and I imagine the same thing is true at Coppin. In the mandatory fees, 33% of the mandatory fees are for athletic fees. Something is wrong with that picture, but yet and still technology is about 10. And if your campus is anything like ours, technology is always broken. And so I just, I'm glad to be here. I can get carried away. My wife told me, say, you're gonna have a heart attack. And I remember what Sam Houston said. I'd rather die on my feet than die on my knees in any day. And nobody's gonna be praying. Okay?
Good evening to this distinguished audience. Good evening to the distinguished panel and moderator, Mr. Curry. I'm very, very honored to be a part of this distinguished panel. Although Professor and Dean John Britton called us old.
My classmate.
My classmate and my frat brother at Howard University. I'm still glad to see that he is looking so well. The opportunity that I have to be here, historically, I am an attorney who has been in the civil rights struggle as a lawyer, particularly in Maryland, but across the country, for 40 years. If you add 3 years to that, when I came out of Howard University, I went to the Small Business Administration. And even though that was the Nixon administration, it was the beginning and the birth of affirmative action. So my first assignment was to defend affirmative action. And so when you couple that with the other 40 years, that's 43 years I have been in the ring in terms of civil rights and advocacy for the civil rights of all, and that includes in education, the workplace, and what have you. And having said that, what brings me, I think, to this panel, and what brings my excitement in terms of the struggle and the battle that we're in terms of HBCUs, not only did I graduate from HBCU, Howard University, as I indicated, and Howard University Law, but I was appointed to the Board of Regents by Governor Ehrlich. And my assignment at the time of the initiation that I was given from the governor was to go in and fight for the HBCUs. And at that point in time, the HBCUs, including Coppin, were practically forsaken and forgotten. Talking about Mr. Kerwin, who is the chancellor, which we're going to open up the discussion, which I agree is the backbone of a lot of these difficulties that the HBCUs are facing. When I resigned, or when I resigned, but my second term expired from the Board of Regents, he addressed me as the conscience of the Board of Regents. And I took that as a tremendous compliment, because when this suit was filed by the coalition, I was the one vote on the Board of Regents that voted no. And when the duplication issue came up, I was the one that was given a 5-minute speech when the chairman had to recognize me with me pounding on the table like some other persons had pounded their shoes on the table until I got the attention and got the floor. And so I bring to that, or to this struggle, that type of intimate knowledge in terms of what has happened within the educational system of Maryland. I am so happy that the judge has ruled as she ruled. I'm so happy that we are in a mediation situation, although I'm so much more happy that she retains jurisdiction. So if the mediation is unsuccessful, it goes back to the U.S. District Court with these fine learned counsel and chairman of that of the coalition. And so I'm very glad how this is unfolding. I've just released a book, Under Color of Law, and the basis of that book is that we as a people have to be very, very aware that America is moving in the negative and is retreating from the civil rights of which so many people died and gave so much blood. If we look at what's happening in the education system as we're speaking of tonight, if we're looking what's happening in the penal system, if we're looking what's happening in the dismantling of affirmative action, if we're looking at what's happening in the dismantling of the Voting Rights Act, if we look at what's happening in the economic plight of our people in this society, America is in a negative mood and posture, and we must arrest that and turn it around and move back forward. So I'm very, very happy to be here and join this distinguished group in the panel discussion and look forward to your questions. Thank you very much.
Thank you. Don't we have a great all-star lineup here? Before we get into the case itself, I think we need to add a little context. I want you to bear with me. I used to cover Jesse Jackson's first presidential campaign. He would say, text without context is pretext. I don't know what that means, but it sounds good. But I was looking at the judge's opinion, at the very beginning, this is what she said. As the parties involved in this long-running litigation agree, Maryland had a shameful history of de jure segregation throughout much of the past century. Public higher education opportunities for African Americans were either non-existent or decidedly inferior to the opportunities afforded to white citizens. She started off the opinion that way. So I want, before we bring it up to the present, let's talk a little bit about that period. What was it like for African Americans when they first established the education system here? It doesn't matter who starts first.
Well, I guess they're all looking at me. Well, I think the history is little change since the beginning, and I think that was the point of the judge's reference there. Our historically black colleges were born of protest and inequality. From the very, very beginning, they were started separate from the white higher education community. It was through the sheer force and pressure from our blacks and missionary whites that we, in fact, forced our government to come to the table. I think if you go back to the 1830s, one of the first of our historically black colleges was Cheney in Pennsylvania. Cheney was one of those institutions that started as private institutions. The government wouldn't even start the institutions. Most of us started as private institutions, and it was through the work, as I said, of religious organizations and missionaries that said that if nothing more, we don't want to have illiterate citizens. They are a burden on society. It didn't say whether or not they liked black people, whether or not they accepted them as equals. They just understood the burden of ignorance. They understood the burden of ignorance on a society and said, we must do something about this. And so you had coming into being the Cheney states and the Wilberforces. They were the first ones. And then the Lincolns, the private institutions. And then the Civil War, because still our states resisted. I'll say that again. Our states resisted and did not come to the table. It was not until after the Civil War that we began to have some of our private black colleges become public institutions. And for institutions in Maryland, you were well into the 1900s before the state took them over. And they didn't take them over on their own. It was because our federal government said, no, you're not going to continue to receive funding from the federal government unless you provide equal educational opportunity. And when you think about all of this, that's exactly what we're asking for, equal educational opportunity. And to the extent that a student, whether he's black or white, can come to a Morgan, who was founded in 1867 and in 1939 became a public institution. And it became a public institution because the state needed that and asked that Morgan State become a public institution. Since becoming a public institution, like all of our other black institutions, and by the way, I'm one of those who believe that if you don't hang together, you're hanged separately. And so when I go to the table, when I used to discuss Morgan State University, I'd be discussing Coppin and Bowie and Coppin too, or Coppin, Bowie, and Morgan as well, UMES on the Eastern Shore, my own alma mater. Because I think that if we don't do that, if we don't come as a solid block, then we leave ourselves vulnerable to be hung. And that was the story of our black institutions. They only became because of the force of black communities and black power like yours. And we have to remember that as we come tonight, that if we want there to be a change, if we want our institutions to be as competitive as our counterparts, we have to make sure that our voices are heard and that our feet are all over the state of Maryland as these elections are taking place. They have to make a commitment to us that they believe in our historically black college.
Dr. Richardson, you said the state needed Morgan. How so?
I'm sorry?
You said the state needed Morgan to become a public institution. Please explain.
Well, because the federal government was saying that even though we have a separate but equal, you know, we had the Ferguson case, Plessy versus Ferguson, yes. And that said that separate but equal, and we knew it was unequal. It said that, in fact, if you're going to continue to take money from the federal government, that you're going to have to provide equal educational opportunity. And of course, after 1954 and then 1964, you know what's happening here, Brown in 54, and then civil rights in 64, and then along comes the Adams case, and then here we are with Fordyce. And had the people in Mississippi not given us Fordyce, where would we be? And so the Maryland litigation now becomes an extension, the next generation of the Fordyce case. We don't want just what came out of Fordyce, we want to go beyond what came out of Fordyce. And when you talk about the 1890 versus the 1862 land-grant institutions, just a quick note on that. In 1862, there was a Morrill Act that said that we need to have universities that provide the kind of curriculum that supports our national defense, agriculture, and teacher education, and some of the other areas that had been laid out. The intent of the federal government that all would benefit from the 1862, but when it did not, then the federal government forced another step, and it was the 1890 land grant. That was the black land grant institutions. They created them in the states because the federal government was putting pressure that you have to provide equal educational opportunity. And so it's with that history that we're still struggling. We're struggling now under the umbrella of Fordyce to bring that same equality to our public institutions. They didn't do it before, but they must do it now. And the reason they must do it now is because our economy has changed. You don't have a margin. It is often said that when other institutions catch a cold, we catch pneumonia, and if you're not careful, we'll die. We will only die when we ensure that the pneumonia is cured, and the pneumonia in this case is lack of investment. Lack of investment. I will say to you that unless we have that investment in our institutions, which for a period may be disproportionate, But that's what you have to do to a business too. There's a period in which you have to infuse resources to get it to viability. And that's what we must need here. When we're talking about retention and graduation rates, when we're talking about attracting a diverse student body, and let no one tell you that our historically black colleges are just black enclaves, that indeed there are just institutions that don't want white students. No, we are public institutions that want to be competitive for students regardless of their race.
Let me interrupt here a minute. I'm going to try to move this on. I want the other panelists to respond to this. What I found most striking, going back through the court documents, were the number of special commissions that were appointed and reached the same conclusions. In 1937, there was a SOPA commission, and it said a crisis has arisen in the field of higher education for Negroes in Maryland. That's what they used to call y'all. The cause is that the state of Maryland has failed to make adequate provisions for Negroes in the branch of education. Now that was 77 years ago. Then in 1947, 10 years later, another commission, the Marlborough Commission, concluded that none of the black colleges in Maryland, quote, was equal in quality to corresponding institution maintained for the white population. And then in 1950, yet another commission, the Wigland Commission, declared the continuous uphill struggle on the part of Negro colleges to secure facilities on par with white institutions is a factor which cannot be overlooked in a survey of this kind. Now, this was all before Brown. Why hasn't the state of Maryland caught on?
Brother Curry, you would get an A in reading the opinion and comprehending the message. The plaintiffs in the coalition suit literally hung Maryland on its own petard of all these studies over the years, that not only the ones you've mentioned, but there have been not one, but two agreements with the United States Department of Education, the Office for Civil Rights, in which it was what you call a consent decree, that unless Maryland changed, the federal government was going to sue them and it was going to withhold funding. So Maryland agreed to not one but two agreements in order to fulfill its terms. They were called partnership agreements, and Maryland has failed to live up to the terms of either one. So in 2006, with not only David Burton and the outstanding alums of all of the 4 HBCUs who formed the coalition, and of course, the studious record keeping of Dr. Earl Richardson over the years as president of Morgan State, he came to me with about 12.5 binders, thick, with every letter, every memorandum, every correspondence between Morgan and what is known as the Maryland Higher Education Commission, or MHEC, and they were the prime defendants. So in 2006, we brought suit under Title VI of the 1964 Civil Rights Act, which we're now celebrating the 50th anniversary, along with the 60th anniversary of Brown versus the Board of Education on Thursday, May the 17th, and under the Equal Protection Clause of the 14th Amendment. And in this opinion, everybody's referring to, and everyone should read, particularly for the history lesson, not necessarily the legalese, but for the history lesson on the sad state of Maryland, that today, in terms of legal segregation in higher education, Maryland is worse than Mississippi. And the court found Maryland liable for violating the Constitution through what is called unnecessary program duplication, and suggested the parties enter mediation, and that's where we are now. So the case is divided into what is called liability and remedy. The court found liability against the state of Maryland that it violated the Constitution. It withheld a remedy pending this mediation. I'll talk about that later. But let me give you an example of unnecessary duplication as a definition. Morgan was first in time, first in right, even though under Jim Crow segregation, created a master's in business administration. Along in the early 2000s, Towson came along, and it wanted to create a master's in business administration. By the way, since Morgan was the only one of the local institutions of higher learning that had this program, it attracted substantial whites and non-whites as what's later going to become a high-demand, unique program. And Townsend asked the state agency, the Maryland Higher Education Commission, if it could open a Master's of Business program. And the state hemmed and hawed because the federal government was breathing down its back, and because this unnecessary duplication, where a traditionally black institution, a historically black institution, first had the program, and then the traditionally white institution came along to duplicate the program, would result in the historical, sociological phenomenon that whites will go to the, quote, white school, and blacks will go to the black school. Therefore, notwithstanding 20, 30, 40, up to now 50 years after the Civil Rights Act, Maryland still maintains the de jure system of education by duplicating educational programs. Now, Maryland didn't stop there. They were pushed back at first, so they went over to the University of Baltimore. Now, the University of Baltimore, the court found, was a duplication in itself, because before the 1970s, it was a private institution that almost went out of business and went bankrupt. The state came along and bought the University of Maryland, a 2-year junior and senior, and a graduate in law and business and others. That was a duplication itself, but in any event, it got in the back door with it, and it was like, you mean just because you have juniors and seniors, you don't have any freshmen and sophomores, you're not duplicating what Morgan is doing? But nevertheless, it went over to University of Baltimore, Townsend that is, and said, look, the state won't let us have one, but suppose we tag on to yours, and suppose we say our students will go to our school, they will get the MBA from us, but we will on paper be a part of yours, and therefore we'll be getting in the back door. So that's an example of unnecessary duplication, but not only is the MBA and many other programs a duplication, but the University of Baltimore is a duplication itself. And the University of Maryland, Baltimore County, is a duplication itself, because they've all come in on top of Morgan, on top of Coppin, right here in Baltimore, and duplicated the educational programs. That is the signature constitutional violation that this court found was wrong. And this all stems from a 1993 case called Fordyce versus Mississippi, in which Mississippi civil rights advocates on behalf of Jackson State and Alcorn, Mississippi Valley State, did the same thing then that the alums of the 4 HBCUs are doing now. And the court said that these state institutions, which created institutions of higher learning under the definition of an HBCU, an institution that was created to maintain segregation in the white institutions by refusing to allow blacks to attend white institutions of higher learning and relegating them under the Plessy versus Ferguson to the black institutions. That is the definition of an HBCU. And so it came along in Mississippi, where Mississippi said all of a sudden, we're going to stop segregating. We're going to now treat all the institutions as equal. We're going to create this, by the way, ACT score, that's the other side of the LSAT for college admissions determination. We're going to make it, SAT, excuse me, and we're going to make it equal for all. But we're going to set it at such a high bar that it's going to eliminate large numbers of black students. And the court said, no, you just can't stop and say you're not going to segregate anymore and not turn back and look at what you've created and try and remedy it and do something about it. And so it found that all the duplication at the University of Maryland, which was trying to move into Jackson, Mississippi, where it's 3 hours north, up in Oxford, Mississippi, and create a whole new institution, was going to be a duplication. And Fordyce was the case that held that states with historically black institutions of higher learning could no longer duplicate programs and compete against traditional white institutions, and it violated the 14th Amendment Equal Protection Clause, and it perpetuated the de jure segregation in higher education long after the de jure ended and de facto segregation continued.
I don't want to skip over this part. I come to you. I want to skip this part. Now, Brown was the decision in '54. Now, what happened with Maryland? How did Maryland react to that?
Well, Maryland actually reacted with, defiance and arrogance, which is really the problem we have today. We're still defiant and arrogant.
You're right.
And so in 1969, actually, the Office of Civil Rights actually came and approached the state of Maryland and said, state, you're one of about 10 states.
Yeah, 10, it was exactly 10.
Okay, 10 states, I'm getting my numbers right, who have failed to desegregate your system of higher education. So imagine a state like Maryland now. Remember, we're a progressive state, correct? That's what we call ourselves, a progressive state. And so, so the Office of Civil Rights concluded that we continue to operate a system of segregation in terms of our higher education system. And then there was another commission, because Maryland likes to establish commissions, in 1974, the Cox Commission, and that commission really described the inequities and the disadvantages of the HBCUs and called upon the state to enhance HBCUs to the level of traditionally white institutions. So back in 1974, this issue of parity and comparability was discussed, and there was a commission that actually made certain recommendations. So why are we here? Because Maryland has never fully implemented any recommendations or any sets of recommendations that its own commission that we're paying for as taxpayers, we're paying for. Maryland has taken these reports and essentially done nothing with them. And that's why we continue to be where we are, which is a big problem. And then we had the Fordyce decision, of course. And then, because Maryland still did not comply with taking affirmative steps to erase and dismantle the issues of the de jure era, we ended up in a 2000 a partnership agreement with the Office of Civil Rights, in which Maryland agrees to avoid unnecessary program duplication. Interesting, because under, the case that was brought by the coalition, the issue in which the plaintiffs were prevailed was on the issue of unnecessary program duplication. This is a huge issue for our state because the state has a black eye. Don't let the governor or anyone else tell you any different. This is a significant finding. The state of Maryland was found to have violated the constitutional rights of students in this state, that we are maintaining, not that we did it in the past, but we have maintained a system of a separate but equal system in our higher education. The reason why this is so significant is because if Maryland's current policies and practices were not discriminatory, the current policies and practices were not discriminatory under Fordyce, the plaintiffs would have not prevailed, okay? Which means Maryland's current system, modern day system of determining which programs can be at what universities is discriminatory. That is not, we cannot tolerate that as a state, as a legislature, as taxpayers. This is a problem not just for black students, but white students, Asian students, Hispanic students. You know, we are one Maryland. And all of our institutions deserve to be treated fairly and equally. We cannot live in a state where we allow and we tolerate discrimination. That just does not make sense for a progressive state like Maryland. And that's why we're here today, I believe, and I know we'll continue to talk about this issue, but the reality is we're here because Maryland has violated our collective constitutional rights, and that is a significant problem for this state.
I got you. Doug, before we do that, I'll come to you, John. Isn't it also true, I'm going to leave this alone when I make this point, isn't it also true that after Brown was handed down by the Supreme Court, that Maryland for another 10 years still had separate but equal schools?
Yes,
So
that's
for
correct.
Roanoke School?
That's correct, for 60 to 20 years. But let me just tack one on.
I'm a direct descendant of Brown.
Go ahead.
Pettit versus the Board of Education of Harford County. And that decision, when my father took my case into federal court in 1958, Brown came down in 1954. I was ordered into high school in 1960. And so Maryland was still in defiance, and the federal judge here, chief judge of the Maryland State District Court, did not rule and allow me into the school in terms of Brown. But he reached back to Plessy versus Ferguson and said he made a determination that the black schools and the white schools in Harford County were unequal. So therefore, we were in violation, they were in violation of separate but equal, not in violation of Brown. So that's how defiant Maryland was. And if I could just for a second, Mr. Kern, the point here is that this state and the officials of this state are acting with such arrogance and impunity that it shocks the conscience. And for that type of arrogance not only to have existed in prior administrations, but to exist now at the time of an election, and still will not address the issue, still will not touch the issue, still will not move forward on the issue, but will in fact run for governor, run for president, run for attorney general, and still in fact deny the effects of Brown and Forsyth is a stage of arrogance that is unbelievable. And let me just finish that by saying, I sit on the Board of Regents, and when both of the cases came up by the coalition in terms of duplication, I already indicated my vote against the duplication, but I was on the Board of Regents when the Assistant Attorney General at that time would come in and advise us, and this was on a monthly basis when the Board of Regents would meet, that Maryland was in defiance and acting in an unconstitutional way, and those people, through the leadership of Mr. William Curran, still voted for duplication knowing they were in violation of law.
And let me go one further. If we were gambling, I would call and raise you, Dwight. Right now, you've heard that this case called U.S. versus Fordyce is to equal educational opportunity in colleges and universities what Brown versus Board of Education was to K through 12 education. Your governor, named O'Malley, your lieutenant governor, named Brown, your attorney general, named Gansler, who's also coincidentally a candidate for office. All of them have indicated in court that they're going to defy even further, and no matter how much they lose this case, they're going to appeal it, and they're prepared to appeal it all the way to the United States Supreme Court, and they're going to say that Fordyce is no longer good law. Fordyce should be reversed. Black colleges today no longer have any more rights, and they're going to pray that this Supreme Court remains conservative, and like they knocked down the Voting Rights Act last year, like they have affirmative action on the ropes, just like they held this week, and I'm giving a major talk on Friday, in this Michigan Supreme Court decided 3 weeks ago called Schuette. And Schuette said that the voters of Michigan can ban affirmative action anytime they want to. White people can ban affirmative action by the ballot. And so when you go out there today, as Dwight said, the people who have been standing in the door, like James Wallace, are the governor and the attorney general and the lieutenant governor. And even when you go out for these attorney general candidates, there's a person named Frosch, and there's a person named Cardin, and of course we know Brave Boy. But you go ask Frosch, and you go ask Cardin, what are you going to do about the Fordyce case? Are you going to try and reverse it like Gansler is doing? And he's probably going to say, I don't know about it. And say, well, I got you. Because if you don't know about the most significant case in civil rights in Maryland affecting higher education decided in 2013, you're unqualified to be the Attorney General of the state of Maryland. But you know where Brave Boy stands.
Let me just say.
Senator, let him go first and you be next, okay? I've been promising he's trying to get in.
No, okay.
I'll come right next to you. Usually I let women go first, but he's been waiting a long time.
Yes, what happens, the black leaders, our presidents at these institutions, give these people the emphasis to say what they're saying. This was the question that was asked our president at the court hearing. In terms of progress, this is Dr. Burnham, this question was asked. I believe you testified you see no evidence that segregated system continued or that progress continued. Is that right? And he said yes. He answered yes. And your president, former president, Dr. Burnett, he was over MHEC when this vote was taken.
Yes, he was.
And he came over to Bowie trying to talk us, said, well, you know, Maryland has done all they're supposed to do. I told him, get out of there. He lied. And the commission, the members of the commission voted not to give Townsend the program. Burnett voted, and he was the chair, he gave them the program. The same thing happened when we were in the college system. Dr. Burnett, Dr. Lyons, the faculty, alumni of these institutions did not want to go in. We would be able to fight the battle with Morgan. But they voted against everyone else's wishes and put us in this system. And so that plantation mentality with the chancellor over the plantation and our presidents, that, you know what, in person in the house, that's what's happening to our black schools.
Senator.
I just want to pancake on what the panelists are saying, because actually Delegate Brayboy is right. In terms of OCR, OCR came to the state of Maryland in 1996, and at the time it was 10, and it dropped to 7. And now currently there are 4 states who are still in violation of the Office of Civil Rights, and Maryland is one of them. And we're supposed to be so progressive. But just let me tell you a little bit about Senate Bill 169. What Senate Bill 169 did, and that was the bill that was there this legislative session. Number one, it changed unreasonable back to unnecessary. Duplication, right, because it was unreasonable. It was unnecessary duplication, and the state of Maryland made it unreasonable. So the bill, number one, changed it back to unnecessary. Number two, what the bill did, just based on the suit where the court had decided and Judge Blake decided, I had codified federal law into state law, and I said instead of going to federal court, let's move on very quickly. We'll go to circuit, okay? They didn't want to do any of that. They didn't want to go to circuit. But the real issue is this, you know, and there's no doubt in my mind that Maryland knows that they're in violation. And to go to remediation because, you know, the leaders over there tried to tell me that no decision was entered. I said, oh no, the decision was entered. And I argued with my president about it on the floor. But I told him what it is. The final judgment have not been entered. And it goes back and the judge will make that decision. But interestingly enough, what they said to me, that Fordyce, which I stand on along with the constitutional laws that they're in violation, they said that's not law. I said, excuse me? Fordyce is not law? They said, no, that's judge law. I said, well, let me tell you something. Judge law, whatever you want to call it, it was good enough for Mississippi. It was good enough for Texas. It's good enough for Alabama. And you tell me it's not good enough for Maryland. But see, it's a stall tactic in terms of exactly what Mr. Britton said. If they stall long enough, they want to stall long enough because they're waiting for the Fourth Circuit to change. But I think by the time this gets to the Fourth Circuit going to look a little different, believe it or not. But ultimately, yeah, they made some changes. So they're not very happy about it, but they know that they owe the historically black institution billions of dollars. So it's only a stall tactic to carry it all the way up. So, you know, finally they'll give up and say, oh, we have to pay. So it's just stall. I told them from day one when they said they were going to mediation. Mediation not going to mean a thing. You're stalling. They're never going to agree from day one when they entered into mediation, okay? Dr. Richardson, did y'all agree yet? Now, you know I know the answer to that question. Thank you, but that's where we are. But they just do not want, and they told me, Conway, you don't need to do this because you making us look like Texas, Alabama, Mississippi. I said, you know, I thought I was in Maryland, but I think I'm in Texas, Alabama, or Mississippi right now.
Dr. Richardson, I don't want to miss this point because I want people to understand the impact of this duplication.
Sure.
Now, before these programs were duplicated, weren't whites attending black colleges at a larger number?
Sure.
And those numbers declined after
Yeah,
duplication?
sure.
Help me out with that.
Sure they were.
Yes, that's the tragedy of all of this, is that if you look at our historically black colleges during the 70s, remember that's just after the Civil Rights Movement, and that's after the Civil Rights Act of '64. There was great momentum in this country about doing the right thing. And so they began to start emphasizing that there would be no duplication. About 1976, they established the Maryland Higher Education Commission, but it wasn't called that then. It was called the State Board for Higher Education, and Dr. Emery, who's in the audience, was a member of that commission. And that was the agency that had the responsibility for overseeing the desegregation of Maryland higher education. By the way, they are now dismantling that agency.
Amen.
That is another part of moving back that Mr. Pettit was talking about. They are destroying the agency that was established to oversee desegregation. They have gone from a total of about 80-some employees that did all of this monitoring down to, I think, half that. They're down in the 40s now. So the idea is that we remove that agency with its vigilance and looking over and supervising this, it'll be easier for us to do the things that we've done undercover, and that is to continue to duplicate programs and to continue to fund them at those other institutions as opposed to this institution. Let me make the point. I think the data was presented to the court that showed that during the 70s, let's take one of our institutions. I won't go with the macro numbers, one of them. How many remember Bowie State? The conversation during the early 80s is that, well, Bowie State is truly a diverse university. Bowie State has about 39% white students. Roll forward to 2000. Bowie State has less than 10%, probably around 7%.
It's lower than that.
Okay, now lower than that, I'm told. What happened? What happened? Well, one of the things we found when we looked at all of that, we asked Bowie. Bowie couldn't tell us right up front what had happened to them. I'm not sure they knew. But when you look at the numbers, where those students were, information management science, managerial science, and those areas, where it was large enrollments overall and large white enrollments. Well, what happened? Was it mismanagement at Bowie that caused that? No. What happened is, if you trace the program duplication, you found that the University of Maryland, University College, began to establish those programs, and now that population has moved from Bowie to University College.
Online.
Now, well, not just online. That's what most of us sometimes understand when we hear University College. No. University College built satellite campuses around Bowie. Largo, a main campus at Delphi, and maybe a little bit over at Shady Grove.
Shady Grove, definitely.
Okay, all right? That's what has happened to the enrollment, duplication, okay? So you see the harm that duplication brings to a campus. Now, had Bowie been able to grow and develop in those programs, continue to grow, it would have required more facilities, more money, more faculty. You see what I mean? That's what happens to a university that gives it its ability to grow and to develop and be a major force in that community. Well, let's look at Coppin. Yes, I was so proud when I came on Coppin's campus and saw some of the buildings that they need. let me underline that, some of the buildings that they need, okay? I think it's beautiful what I see on the other side of North Avenue, but how did that come to be? In 1999, 2000, the OCR, Office of Civil Rights, came to Maryland with a little urging, by the way. I don't know who it was, but with a little urging. And out of that discussion came the Toll Commission. It was in the agreement that was written in 2000 that they would do a special study of Coppin. That's a toll commission that said there would be about $350 million that should be invested in capital resources here. That came out of this effort you see underway here right now. That was the beginning of it. Understand it. Some of us are now seeing some of those facilities on our campus coming up slowly now, but it's under pressure of this case. Trying to now saying, well, we loved them all the time. They just didn't know it. And so my point in all of this is there is a history, and it's documented what the negative impacts of duplication are. Let me talk about copying. Again, in terms of the academic program duplication. That 2-year at the University of Baltimore, when you then put in the other 2 years, it then is in competition with Coppin State in those same areas. Those are the students that are coming to the University of Baltimore that could otherwise come to either Coppin or Boyd. It has negative impacts. Let me talk about, again, the harm. When our students go to see these beautiful campuses, Coppin, or UMBC, Towson, they say, why don't we have that? And they should. Our students have a right to ask those questions. Why don't we have it? One thing about being born in a capitalistic society, whether you come from the hood or whether or not you come from Rittenhouse Square, you want the very best that America has to offer. And so when you go next door and you see all of those beautiful facilities and all the nice services, yes, our students ask, and they come back, and sometimes when we don't get to educate them in their naivete, they think it's because our administrations don't care. They're not interested. No, 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 no. They understand it well. They just don't control the money. They can control the vision, but not the money.
Gotcha. Good point.
And a vision without money is nothing.
I want to do this. I'm going to go to David because I got a question for you. Then I'm going to go questions from the audience. So if you have questions, no statements, no observations, no reflections. If a question, go to the microphone. Dave, I want to ask you where we are in the status of in terms of mediation and what kind of strategies can we have going forward? And I want you those with us, help me strategize. How do we get students mobilized? How do we get faculty mobilized? How do we keep the pressure on?
Well, I think this event is certainly part of the strategy of public awareness, but I think we have to convene as a body of HBCU alumni and friends of HBCU alumni to look at the larger picture here. And I would like to add just one more perspective
Sure, absolutely.
to what has been said here. My background, of course, is in strategic planning, et cetera, et cetera, et cetera. And I think in this case, I think it's important for you to understand that we started this whole process with the end in mind. We knew we would be here. And the coalition is an effective organization because we are not the state. Were the state to have gotten involved, or some of the presidents and others, employees of the state were to have gotten directly involved, it would have been like suing themselves. So I think we have a model here that is replicable in other states. Other states are watching the state of Maryland, as has been said here by many here tonight. The state of Maryland is in the spotlight because what happens here could happen in other states, and that's what is the fear of other states, especially other attorney generals, who are watching to see how this unfolds. I wanted to have added on the first end of my statements the fact that one of the things that really concerned me was the state strategy in wanting to look at the TWIs as being minority-serving institutions.
TWI defined.
They want
Oh, I know what it
TWIs to
is, but-
become minority-serving institutions. And if you look at the whole concept of what's happening in America, I'm going back to what Dwight said earlier, because if I were to write a book today, it would be called The Gestalt of Injustice in this country. And this is just one of the squares in that larger gestalt. Add to that voting rights and all the things that Dwight mentioned. And this is one square that we cannot afford to lose, because I think HBCUs are a major economic tool of black population in this country. It's the last frontier for economic empowerment of black families, basically, because no other minority organization or population group has HBCUs like we, except for some, Spanish-serving institutions. So I think it's very, very important that our strategy is one of economic development and one of empowerment of others around the country. So I think we need to regroup, the original coalition, those that participated, and look at what we need to do as, not just in the state of Maryland, but maybe as a country in terms of looking at HBCU rally. I mean, there are a lot of people in this country that don't know about this case. There are a lot of people in Maryland that don't know about this case. A lot of HBCU graduates in the city of Baltimore that don't know about this case. And we have to do something about that immediately, because to prosecute this victory, to execute this win, it's going to take those that are immediately impacted, those who will be impacted, and that's the audience here. So I would think that one takeaway here tonight would be, number one, to challenge our our candidates for governor and lieutenant governor. I went to a governor's debate in Montgomery County, where I live. I heard the word HBCU mentioned one time.
Exactly, one time.
One time. And it had to do with buying them off, giving them more money. And never about the case. So to your point, we've got to educate the general population on what this case is all about, where it is, and where it can go unless we rally now to communicate more to the alumni in terms of where it is. And where the case is now is a very delicate point. To Senator Conway's point, or her expectation has come true in terms of what the state is doing. So we're in a very delicate position strategy-wise. I won't go into all of that, but the important thing is now it does go back to the court. And when it goes back to the court, she needs to hear a resounding voice of the collective voice of HBCU interested parties in the state of Maryland. So I would be interested in following up on this group tonight to see what you feel is next, to reach out to the people who are not here and educating them on why we need to take this discussion initially to our political candidates, because that's, if there's any forum that takes place in this country, you need to be there to ask the question.
I'll say that Jake has been doing a lot of stories in the Afro.
Well, he's
And
my
I
hero.
run- And so whenever Jake Oliver sends me a story, we send out our national wire that goes to all our black
Yeah.
newspapers. There's a lot of interest in this case. So what else we do? What do we do to strengthen the coalition? I'm really interested. How do we keep the pressure on? John?
Some ask, what is the remedy? And we've outlined about 4 different strategies. Number one, you must create some new high-demand and unique programs at the HBCUs to attract a multi-diverse, racially, ethnically, economically, educational achievement to those institutions to build them up. 2, we must transfer some non-core programs, especially high-demand programs, from the traditional white institutions to the HBCUs. 3, we must merge some programs between the TWIs and the HBIs as needed. And 4, there must be some institutional merger of the University of Baltimore with Morgan in the lead.
Okay, all right.
Ooh, great job.
All right, let's go to questions. You got a question, sir?
That law school, part of Morgan?
Well, Howard Law School taught you well.
Yes, I just want to thank the president of Compton
Speaking to the mic.
for putting on this very important town hall meeting, I want to state that we are having a conference. All right, and other people. Thank you.
First of all, they didn't put it on. Let's make sure we don't get anybody in trouble.
All right, I
All
don't
right.
want to, yeah.
You
We're
get
having a conference in Atlanta, Georgia, at Clark University, in which Mr. Britton has just signed on, in which we're taking the case of HBCUs to the United Nations.
You said we. Who's we?
The AFRAM is the acronym is the International Organization for American Minorities,
Okay.
and which is the African American branch. Mr. Britton has agreed to come on as a keynote speaker, also the president of Clark University, because we feel that this, as we move, as they are cutting off all grounds for civil rights, we need to look at human rights
Okay.
and let the world know what is going on. I have information for those
Great.
who are interested in this. I'm the author of How Black Colleges Are Turning White, the Ethnic Cleansing of HBCUs in the Age of Obama, where I dealt with this issue back in 2011.
Okay, thank you.
Thank you.
Well, I got 15 minutes, so I'm going to try to get as many questions as I can. Yes.
Yes, can you hear me?
Sure.
Yeah. My concern is the foundation of education, which is K through 12. I mean, you know, I don't blame you guys for fighting for this particular case. You know, I'm not trying to, dissuade you from doing that. But what are we going to do about, the lead in the water in the schools, 50% of the kids dropping out? There won't even be a HBCU if we don't send some kids to school, and if they don't graduate from high school. So, why aren't we there? We got to go with the foundation first when we start,
Okay,
But
gotcha.
and then I don't see.
Let me just respond to your question.
Let me
Hold on.
finish, please. And on top of that, I see rec centers and things being closed, but I know my senator, Joan Carter Conway, she's out fighting to keep open the Senator Theater, and don't even mention what's going on with the schools or the rec centers. Or
Got it.
But
things
then you're
like that. So I'm
mistaken,
Excuse me,
asking
excuse
you-
me.
because let me just say
Yeah,
this.
yeah.
We have been sent $1 billion to Baltimore City for the
But where's the money
building of
going?
new
Where's the money
schools.
going at?
Excuse
Where
me,
are the
excuse me,
money
hold
not
on,
going?
time out.
No,
You better
no,
say,
let me just address
time
that.
out, hold on, everybody, time out. This is not that discussion. This is not that discussion. Well, I agree with you, no, you've
It's
had
part
to
of
say,
it. It's
you
part of
had to say,
It's part of
I agree with you, it's not part of one tonight.
But see, that's the problem.
It's not a problem. Excuse me, sir. Hold on. Excuse me. You've had your say. Next. Go ahead.
Good evening. I am
And
Landon.
I'm asking everybody to be brief. We have roughly 15 minutes, so the briefer you are, the more questions we can get in. Go right
I
ahead.
am Landon McLaurin, the president of the Baltimore Metropolitan Chapter
It's a shame you
of the
didn't
National
know
Coalition
what's
of 100
happening
Black
inside.
Women. And I want to take this opportunity to thank the panelists this evening for enlightening us and giving us the historical background on the HBCUs, because I can honestly and truly tell you that I learned a lot tonight. I want to take this opportunity to let you know that as a national advocacy group, we have already started the conversation with regard to the duplication of HBCU programs. And historical Black colleges and universities has always been a top priority for our coalition. We've had the opportunity to meet with Joan Carter Conway, as well as Aisha Braveboard, along with Jake Oliver and other partners. And so my question to you this evening is, as an advocacy organization, how can we partner with you such that we are able to reach a broader audience with regard to what we as a community, an African American community, need to do to get the word out? I'm really concerned that not enough of us understand the plight that we are facing. And so we would like to be able to collectively work with you such that the broader community will be enlightened, will be informed, and will be proactive. Thank you.
All right. Briefly. Let's go. Question.
My name is Winky Campbell from Coppin State University. I'm directing my question directly to Mr. John Britton. you gave 4 things that we should do. 3 of those things were mandated by the judge. I want to know how far you have gone in your initiation so far with your mediation. She said that we should transfer the programs back to the Black Historical Colleges, and that we should get the majority part of it. Now you're in mediation. How far have you gone in mediation?
We've had 1 mediation session. We have 1 more mediation session scheduled, and the judge just the other day announced that she would like to have a report by the end of this month on the status of mediation. For your information, if the mediation, which is all voluntary, fails, then we will go back to court on the 2nd phase of the case in remedy, and the judge will take evidence, either live testimony in court or by written submissions, and she will issue the final part of her decision of the remedy, and she will also give her final judgment in the case.
Okay.
I've got to move quickly. These are going to be the last questions, and you're going to recognize some of the people here. Go ahead, sir, quickly.
Well, my name's Adam Jackson. I'm actually not an HBCU graduate. I graduated from Towson University. Part of my work centers on training young people in public policy and advocacy. And so one of my questions is how do people like me, I'm under 30, I have access to a bunch of young people who are captivated and excited about this case. And so how do we get more young people involved in this effort?
Brief answer, got to be brief. Answer, panelists, brief answer.
Well, we're having a rally.
Because we have 10 minutes to be out of here.
We're having a rally on Monday over at the University of Maryland. And it's because we moved our commencement over there. And that's the only way we feel we might get some news media, the TV. And then from there, we can get other things in. Ms. Bragg back there, she's leading the march for trying to get it. And we need as many people out there as we possibly can at Meserock Road. We're meeting at St. Joseph Catholic Church off of 202 at 7 o'clock. And we're going to be out in front of the University of Maryland on Meserock Road from 8 o'clock to 9:30. And Monday, the 19th, our commencement, and we're using this to get word out that those are other things that we need to be concerned with.
All right, next question.
Yes, my question relates to the unnecessary duplication.
Hold on. Did you just answer a question?
Yes, that's just a topic, and then I'm going to ask a question directly with regard to community.
All right, you got one shot at it. One bite at the apple. We got 10 minutes, literally. So,
Certain community colleges are taking over nursing programs as in Howard County compared with Coppin. And my question is whether or not, to the extent that those community colleges are doing that kind of thing, that's unnecessary duplication.
thank you. All right, one person responds.
Let me just respond to that, because you're absolutely correct. And when we were doing the unduplication in the 4-year institutions, I had questioned MHEC about the duplication. Unfortunately, Fordyce does not apply to the community colleges. But there's an issue with those colleges, because you can remember when the dental program was there, Baltimore County had already approved their building before they transferred the program. They approved the building to put the dental program in and transfer most of it from BCCC to Baltimore County. So, you know, not only do we have a problem with historically black institutions, we have a problem with our institutions in Baltimore City.
Okay, these are going to be the last 4 questions. Go ahead.
All right, good evening to the panelists. The Seven Sisters Colleges was a loose association of liberal arts schools. Can any of you tell me whether there was this problem of duplication and if it had an effect on them and their origins and their sustenance? Can anybody answer that question for me?
Anybody want to answer?
I'm sorry.
The Seven Sisters Colleges was a loose association of liberal arts schools. I'm wondering, because they were so closely associated, did they have the same problem of duplication? And if they did, how did they work it out, or did they not have this problem?
No, as I understood the sister colleges, is that each of them, they work on the same concept that we're advancing here. Differentiated missions and programs, okay? Meaning that you will have one set, University X will have one set of programs. University B will have another set. And the students get the benefit from the total set because of the collaboration between them. That's really what you're suggesting here when you say establish a complementary system of higher education. That is, institutions with specialties, and you don't duplicate it, because when you duplicate it, you're going back to separate but equal. And I won't say anymore, but we could talk a long time about that, but that, I think, gets the response.
All right. Before we go to here, please, reminder to fill out the forms you have. Yes, sir. Go ahead.
I just wanted to know how you guys, as an intellectual panel, how you make a case that we should ask the people who oppress us and who consciously choose to underfund our schools for funding.
Okay.
How can we do that?
Okay. Thank you.
Well, I think because we're taxpayers. And
They already chose that.
Hold on. Let her answer. Let her answer.
We're taxpayers, and we are part of a democracy, and the only way you can actually have a true democracy is if you participate and you hold your public officials accountable. Now, there were a few folks who asked a question about what can we do. I think what we have to do, and we probably can do it right here in the city of Baltimore, is to hold a rally, have our church leaders, have all of our fraternities, sororities, our civil rights community, everyone come, converge in one area, and we just need to pick the place and time, and I'm sure that Senator Joan Carter Conway can find a place and a time very quickly, and we can hold this rally. And what we have to do is develop a questionnaire for everyone who's running for governor to answer the question about whether or not they will support a plan for equity for and comparability for historically black colleges and universities. Our institutions have developed, each of them, a 10-year plan for parity. It's going to cost about $3.2 billion. Yes, I said $3.2 billion, but that is the amount in terms of the historical underfunding that these universities have suffered and faced. And so this is a significant financial commitment that we, as tax-paying citizens, as participants in this democracy, must demand of those who want to lead us. And so it's up to us to stand up, to let them know what we want, and to demand that they deliver.
Okay, next
We've been
question.
demanding since the 1930s, as y'all said.
No, we
Go
have
ahead.
not.
Hold on.
No, we have not.
Oh, next.
No, we have
Go ahead.
not.
Delegate Brayboy pretty much has hit on the question that Ms. McLaurin also asked, just to extend it. What specific marketing efforts should be developed to educate Maryland citizens, particularly prior to the election? We need to get this
them the
out
message
now.
out.
I get the afro, but most folk don't. What do we need to do now to make it happen?
Jake gonna say subscribe to Afro, but somebody else has to answer that.
We can hold a press conference,
Anybody want to respond to that?
and then we can hold a rally.
I can't hear you. Will somebody respond to this question?
So what we've decided up here amongst us is that we're going to pick a date to hold a press conference announcing a rally in support of our historically black colleges and universities, and we will work with the Afro and other newspapers who have an interest in our issues to get the message and the word out so that everyone can converge in a specific location at a specific date and time. We can invite those who want to lead our state. If they want to lead our state in the right progressive direction, then they should be at this rally, and they should answer the question of whether or not they're going to support parity.
Hi, my name is Sherelle Witherspoon. I'm a current member of the Cotton State Alumni. I just wanted to ask, have anybody sent out any surveys to the candidates that's running for office? Are they on board to help us fight for what's right for our community? Or are they just going to be the next ones that's like the Steffers that's already in office that's not doing anything? So have y'all sent out any surveys?
My understanding is that there's not been a survey sent out, but that's something that we here on this panel have to develop and get out to the candidates, and that's why we'll call the press conference and then we'll hold the rally.
Okay. Hi, my name is Ken Morgan, and it reminds me of something that Malcolm X said about up south and down south. So anywhere below the Canadian border is south. Anyway, so...
He also said the battle of the bullet
and a number of other
is the
things.
solution.
But I wanted to be able to put this in a context in reference to the people who took the risk to organize this at Coppin State University. And it included Dr. Cynthia Neverdon Morton. Is she here? She's out there working. Dr. John Hudgens. Who else? Dr. Valletta Bryant, who represented as president of the Faculty Senate, and also our alumni, individuals in our alumni. Could you kind of wave your hand and say who you are? Okay, so this whole idea was to bring this to your attention, to educate, to inform, and to say, what can you do about all of these things? This is just the beginning. This is the easy part. So what we'd like you to do is to really fill out those cards so that we can be in contact with you to follow up if you have ideas, suggestions, etc. So please, please fill out those cards if you want us to be able to follow up and talk with you about these particular kinds of things. And we want to also thank you so, so much for making this a reality. We had some wonderful speakers, but if we didn't have anybody here to talk to, we wouldn't have too much going on. So, but this is just the beginning. So we need your help. We need your input. If you need a number, call 410-951-4187. That's my number. Okay, and we'll also have other particular things. And again, this is not a Ken Morgan or Dr. John Hodgins thing. This is our thing. This is we, us, our university, and we can do various kinds of things to basically help out. One is to faculty. We talked about duplicative programs. If we don't have alternatives for these programs, and the judge says, what you got? And we come up with nothing, then what do we have? So we really, really, really need faculty and students' help to be able to do the hard work that's necessary to build our programs and say, truly, this is what we need.
All right, last thing, the last part. This is the real test. Less than 30 seconds, leave us with thought. Because we're going to get out of here. Less than 30 seconds.
No, I think to Ken's point, I think we need to look at this as a best practice and take this model to every HBCU in Maryland in the short term, and before we even have the rally, but take this to other campuses, same format, same type of input in order to build interest in the next step.
Great idea. Let's come down the line.
And everybody from the advocacy organization that really want to do something, please see me after this, and I'll be glad to connect with you.
Okay. Next. Come on, let's keep it rolling. 30 seconds. You want to pass? Less than 30 seconds. Any parting thought? Within 30 seconds.
Yeah, well, let's get to work.
I would simply say that this is the future of our black colleges, and if we forfeit it, then we've lost the case. Thank you.
I'm done. You're very welcome.
You passed, okay.
You're very good.
I'd like to thank the people for coming, because I'm really surprised that this many are out here. You know, although we would expect it to be filled, but you don't start at the top. The only place you start at the top is digging a grave. And we're not doing that.
We're going to move on.
Let me just make a quick observation. With the Supreme Court's ruling on affirmative action, our kids will be coming back to the historical black colleges. Our kids are already coming back to the historical black colleges. So we have to have the financial wherewithal to be able to accept them and move them through the system in terms of education and graduate them and make them qualified. The last thing I would like to say is that we need, not only with the short period of time that we have, we need to exercise every political opportunity to bring this to the attention of the media and the candidates running for governor. At every stop they make, every place they go, somebody should be hounding them about the question of the HBCUs. And not only that, but we need to also petition all the organizations who are in fact narrating this event and who are putting this event on, that we want this asked as the question. as was said by David, in the debate that I watched last week between the gubernatorial candidates, the question of the HBCU came up, it was mentioned one time in the whole debate. That's unacceptable.
Okay. Want to make sure you're turning your forms. I know I've been a tough taskmaster, but I said we get out on time. I want to thank everybody for cooperating so much, and thank you for coming.
Thank you very much, Delegate. You're so persuasive. David, keep up your good work. Good job. Good job.